Morning everyone, welcome to another Compliance Over Coffee. And this morning, you may think, Tina, you've lost the plot. Learn to read? What is Tina talking about? Haha. Tony says I've lost the plot most days, guys, so it's okay. He's just chuckling, sitting next to me now. Have I lost the plot? No. It's a lesson that we all need to learn. We need to learn to read. And I don't mean learn how to read. I mean learn to read important documents before you sign them. Learn to read them and understand what your documents say. So this is twofold. So from the sourcer perspective, learn to read and understand what all of your documents say, especially your contract between you and your investor. Understand everything that's in it and be able to explain what's in it if you get any questions about it. But more importantly, from the investor side, please read agreements before you sign and return them. Because it doesn't really matter what's in that agreement. If you sign it, you are agreeing to it. Yes, you could say that the clause may be slightly unfair, but you have to prove it. You have to prove it. So it's easier if you read through the whole document, highlight anything that you're not sure about, and ask the questions. Don't just assume that it's a standard NDA, of which there are a ton out there, and people just sign them and think that's what it is. But actually, you've signed up to say, I don't know, you'll pay me £1,000 for every deal I send through to you for you to assess. You sign the agreement, that's it. You've then got to argue that that is unfair. And I can tell you that no solicitor will take it on without having £10,000 or £15,000 of your cash in the bank, because they know the chances of winning in court are slim. Because the hardest thing to prove is a breach of contract or an unfair contract. You could say, well, I'll go to the redress scheme. You can go to the redress scheme, but they don't deal with contract law. So think about it very, very carefully before you sign an agreement. If someone takes a fee up front and the agreement isn't clear about if it's refundable or not, the redress schemes might well act. But if you've signed up to say that you're going to pay a fee up front, you didn't realise you were going to pay, but it was in the contract, it was very, very clear in the terms, the redress schemes, do not argue about fairness of terms when they're clear. So learn to read the agreements. Learn not to sign something without knowing exactly what you are signing up to. Or it is definitely buyer beware. Definitely. On the kick side, as a sourcing agent, ensure that your agreement, whatever it is that your investor has to sign, is incredibly clear about pertinent points. Such as, how much of a fee do you take? When do you take it? Is it refundable? If so, under what circumstances? Under what circumstances will you not refund it? Do you have a clause which states that if the buyer pulls out from a deal with no good reason, they have to pay you a fee? We have in ours. Do you say how a person terminates your agreement? How much notice has to be given? Do you have protection in there that if they terminate the agreement, they still are liable to pay fees for any deals that are going through? Because if you don't, you won't get it. So think about these agreements. Think about what you have in them. Think about clarity. Think about fairness. And for goodness sake, before you sign anything, thoroughly read it. Before you sign it and send it back. If you're unsure about anything, take legal advice. That is Compliance Over Coffee for this morning. I hope you have a fabulous weekend. I hope at least it's dry, even if we don't get any sunshine. Fingers crossed. Tony's chuckling at me. We will be back with you again next Thursday morning at the usual time, 8:30. Until then, Have a fantastic time. I hope there are a lot of barbecues around this weekend, and I'll see you next week. Bye for now.